Gordon, and I am a senior lecturer at the ANU College of Law. I warmly welcome you today to this webinar on behalf of the Diplomacy Training Programme Australian Lawyers for Human Rights and Youth Law Australia. I would firstly like to acknowledge that I live and work in Canberra in Australia on the beautiful lands of the Ngunnawal and Ngambri people, and I pay my respects to elders past and present. I acknowledge that sovereignty over this land was never ceded, and it was and always will be Aboriginal land. I would also like to acknowledge all First Nations people participating in this webinar today, or who will listen to the recording after the event. Aboriginal and Torres Strait Islander people have endured and still do discrimination and injustice here in Australia. And I'd like to acknowledge the bravery and persistence of families who have campaigned for change to the operation of the criminal justice system and child protection systems. Yesterday, we saw change happen after 5 years of such dedicated campaigning with the passing of Fela's bill to ban the use of spit hoods in South Australia. I'd now like to outline a few housekeeping rules and structure of today's webinar. If you could please mute your audio and keep this muted throughout the presentation, and pop any questions that you have into the chat box during the webinar. This would be very much appreciated. My co-moderator, Dr. Noam Peleg, Senior Lecturer at UNSW, will host the question and answer session after the formal presentation and the discussant's observations. Today's webinar is the 9th in a series of webinars. It explores the value of applying the UN Convention on the Rights of the Child and other rights instruments in litigation and in decision-making in cases involving children and young people. It will draw on the direct experience of His Honour Judge Fitzgerald in Aotearoa, New Zealand, who is referring to and employing the Convention on the Rights of the Child, the Convention on the Rights of Persons with Disabilities, and UN general comments in his decisions. His Honour Judge Tony Fitzgerald will reflect on the benefits of applying these instruments in achieving better outcomes for children and young people, as well as reflecting on what that means for children, litigators, the police, social services, and others working with children and young people. There will be learning for all jurisdictions and countries, and we've had participants sign up from over 23 countries around the world for this webinar today, which demonstrates an international appetite for knowledge, learning, and recognises the urgent need to achieve better outcomes for all children and young people worldwide. Contextually, unlike Australia and a number of other countries, Aotearoa New Zealand legislated a requirement in 2019 that any court or other person exercising powers under the Ōranamariki Act 1989 must uphold and respect children's and young people's rights, including those rights set out in the CRC and the CRPD. His Honour Judge Fitzgerald is the first recorded judicial officer in New Zealand to apply the CRPD in his decisions and judgments, and is a true trailblazer in children's rights in his approach to employing the CRC and general comments. It is my great pleasure to pass over to His Honour Judge Fitzgerald, who will speak for around 25 minutes. This will be followed by some brief observations from the moderators, and then the proceedings will be opened up for a chaired question and answer session. Kia ora, Your Honour Judge Fitzgerald, warm welcome, and we very much have been looking forward to listening to your presentation.
Tēnā koe Faith, tēnā koutou katoa. Ka tīmata ki oti puti, ki ka puku tumaha ka maunga, ki whakahiri ka moana, ki taku kāinga o mua. Ka whakawhiti ki Tāmaki Makaurau, ki kohi maramara ki taku kāinga o Naenei. Ko Tony Fitzgerald takawingawa, ko au tatahi kai whakawa, o ti koti arohi, o ti koti a whānau, me ti koti taiohi o Tāmaki Makaurau anō hoki. Ngā mihi mahana kia koutou. I'll just put the first, or we're clear to put the first slide up here. because I've just explained that I'm originally from Dunedin, which is near the bottom of the South Island that you should be able to see there. But I now live in Auckland towards the top end of the North Island, and I'm a judge at the District Court, Family Court and Youth Court. And I'm sending warm greetings to you all, those who are here in Aotearoa, New Zealand, on both the North and South Islands, and to all of you there on the West Island, our good Australian friends. And to know that there are others from countries even further afield joining us is awesome. Kia ora koutou. And actually, I join faith in acknowledging tangata whenua, the people of the land, the traditional owners of our countries. Ngā mihi nui kia koutou, tēnā tātou katoa. Greetings to us all. And I'll take away the first slide. And the second slide, please, take away. And the third slide, take away. Now, I've been invited to speak about use of the Children's Rights Convention, the CRC, the Convention on the Rights of Persons with Disabilities, the CRPD, in decision-making. But I must begin by owning up to being a novice in terms of my understanding of these conventions and the related UN instruments. But I have a duty to respect and uphold the rights under those conventions of every single child and young person I meet in the youth court, and all of those I meet in the family court regarding their care and protection. And so I've realized the need to greatly increase my understanding and use of these tools. And in that respect, I'm on a journey. What I'm about to say will begin soon with why I set off on that journey, followed by how it's going, and then some what things I will explain at the end. So there are three parts to this: the why, the how, and the what. Just a few things first. When I talk about children from now on, I'm including young people under New Zealand law. Although there are differences between our countries, I think that we are much more alike than we are different. And so I'm hoping that my comments will be helpful to everyone, whichever island you're on. And if any of this is helpful further afield, well, that's wonderful. By way of brief background, New Zealand ratified the CRC in 1993 and the CRPD in 2008. I believe Australia did so in 1990 and 2007 respectively. In New Zealand, over the years, our higher courts have said on numerous occasions that the conventions to which we are a party and other instruments are useful aids, and they provide helpful guidance to the interpretation of our domestic law. But it has not really, well, that's really been the extent of it. As a result, in practice, these instruments have tended to be of limited use, usually only as an add-on to domestic law, an occasional supplement in submissions or decisions. Looking back now, I realize I didn't really understand the significance nor the potential of the conventions, despite having used the CRC as a lawyer and the conventions occasionally as a judge. But that all changed for me during 2019, and there are two reasons why, and this is the why part. The first reason is that on the 1st of July 2019, the law here concerning children in need of care and protection and those in the youth justice system was amended in various important ways. The 29 changes to the Oranga Tamariki Act included significantly enhanced obligations imposed on everyone exercising powers under it. One of those requirements is to respect and uphold the rights of children under the CRC and the CRPD. So that must be done in every case. As I see it, we were being told by Parliament to start making more use of these tools, the conventions that had been sitting in the toolbox a long time, but largely unused. There is a third powerful tool that we have been given, which is the practical commitment that must be demonstrated to the principles of our nation's founding document, the Treaty of Waitangi, and to do that in the way described in the Act, but that is outside the scope of this talk. Well, except to emphasise that the combined effect of these tools, the new provisions of the Act, the conventions and the treaty, in all cases concerning tamariki Maori children, will, I believe, enable truly transformative change. And so the importance of doing that cannot be overstated. The second part of why is that in August 2019, I attended a symposium organised by Dr. Nessa Lynch at Victoria University in Wellington. That was to mark the 30th anniversary of the CRC. Nessa brought together an impressive lineup of people from within New Zealand and overseas. Listening to the discussions and talking to people there opened my mind to the significance of the conventions and their potential. I hadn't previously heard them spoken about or explained the way they were there. Now, I can't explain things as eloquently or as authoritatively as people there did. But what I can do is explain how that spoke to me and how that resonated in my mind with my own work experiences. And there are three things in particular I took away. The first is that ratifying the CRC amounted to a guarantee, a promise that every single child in the country was entitled to every single right and protection in all 54 articles of the convention every day without qualification or compromise. Same goes with the CRPD. These are no simple add-ons or optional extras, and I had seriously underestimated the scope and the scale of these tools. Secondly, in relation to children's rights, all too often in practice, we settle for near enough being good enough. And as a result, we are selling short the very people who most need to have these rights respected and upheld. That is, those for whom that is not currently happening. And I see this in two ways, two dimensions. The first is on a broad scale, there is the fact that in New Zealand, probably about 90% of children have those rights and protections respected and upheld. Most of them completely, the others at least adequately. I suspect it's probably similar in Australia. So I think there is an attitude that actually we're doing pretty well. I mean, 90% is pretty good, isn't it? And for some things, I think absolutely yes. I mean, if I stick to my New Year's resolution to have no more than 2 cups of coffee a day, 90% of the time, I think that's pretty impressive, just quietly. But there are some things where we would never accept that 90% is good enough. Take air traffic control, for example. If those responsible for doing that job got it wrong 1 time out of 10, there would be a huge uproar. And there would be urgent action taken so that bad practice would change. And of course, we should never, ever accept that anything less than 100% is good enough in relation to the well-being of our children, not ever. Now in New Zealand, 10% of children is more than 100,000. That's a lot of children who don't get the rights and protections that were guaranteed to them. They are the ones I see at work every day. But has there been any change in practice for these, the most vulnerable citizens in our country? From where I sit every day, not at all. Deeply embedded bad practice just carries on regardless of the 2019 law changes, and that needs to be called out. And in practice, there are the proxies that Professor Laura Lundy talked about at the symposium, those things that in practice we so readily settle for as being adequate in terms of respecting and upholding children's rights. For example, the phase we went through when pity and protection was emphasised, then the time when listening to voices was prioritised, then well-being became the focus. And of course, all these things have their place. But what was guaranteed to every one of our children was so much more than that, so much more. Which brings me to the third thing. And I have to admit that for the first day of the symposium, as I listened to the talk about rights in such complete and idealized terms, I was thinking, yeah, but that never happens. And yeah, well, that's fine in theory, but that's not what happens in the real world. And then the penny dropped. Kua taka te kapa. And I realized that we must view the rights that way. Because if we lose sight of the ideal, if we lose sight of exactly what has been guaranteed, we are not respecting and upholding those rights. We're settling for less than that, for a compromise. As soon as we drop our sights from the ideal towards which we must aim, we compromise the rights of the child for whom we do that. So, with all these thoughts buzzing around in my head in August 2019, including the teachings of Professor Ursula Kilkelly, with the large poster of the CRC that Bruce Adamson gave me, which fills a wall in my office here to my left, and also the neat little red book, I returned to work. And then on the 18th of September 2019, the UN issued its latest general comment on child justice. Perfect timing. And I acknowledge here Justice Clarence Nelson, who was at the symposium, who I believe was one of the authors of the general comment, but in particular, my good friend, Dr. Faith Gordon, who sent that to me hot off the press. And this brings me to how. Since September 2019, I have been making decisions every day where that document and other convention-related material has been a significant factor in deciding what to do. The first transcribed decision I can find doing that was on the 16th of October 29, and I'll return to that in a moment. What I need to do first is this, and we'll put up the second slide. If we can find the second slide. Got the second slide available? There we go. I need to start with the vibe. I think those of us here in the Antipodes all know what the vibe is, but I apologize to anyone in the international audience who hasn't seen this movie, The Castle. If you haven't, you must. I highly recommend it. We'll take that slide away. And that slide. Every one of us will know the feeling of trying to explain or justify some point we want to make and struggling sometimes to make the reasons sound convincing. That's the bane of a judge's life. But in our own way, I think we all face that from time to time in our respective roles. And you know that you're getting really desperate if the best you can do to support your position is the vibe. And for me, this is where the conventions and the associated instruments come into their own. They enable decisions to be made on a transparent and principled basis that go beyond what was previously possible. There is such deep, rich, current, evidence-based material there that goes beyond what we have available in our domestic law. The first example is that case I mentioned from the 16th of October 2016. It's called Police and HX. And this was about diversion away from formal sentencing for serious offending for a 14-year-old boy. Use of diversion in that way can be a difficult and controversial decision, especially for serious offending, and can be quite hard to articulate reasons simply by reference to the Act. In fact, I doubt you will find a reasoned written decision on that before this. And yet that latest general comment has numerous good reasons why we should be scaling up diversion at all stages of the court process, even for serious offending in appropriate cases. And like so many issues, the convention material not only supports it from a child's right perspective, but it explains why there is such a strong public interest in this, because of what we now know will reduce risks of reoffending. Another example has to do with a child's right to legal representation at the very first point of contact with police for suspected offending. This is one of many issues in a case Police and FG. One of the youth justice principles in the Act here is that children are entitled to special protections during the investigation stage of alleged offending because of their vulnerability. But our domestic law, under our domestic law and based on the leading decisions of our Court of Appeal, the protections in reality are not special at all. Most children are no better off than adults for reasons I explain in that decision. So I looked at what a rights-based approach would mean on this issue and how countries that are familiar with respecting and upholding convention rights would deal with that issue. As it happens, the Grand Chamber of the European Court of Human Rights decided that exact issue in November 2008 and explained in completely unanswerable terms why a child must have legal representation from that point of contact. I know that's not binding on courts here, but if the law is to evolve and if we are to respect and uphold children's convention rights, I believe these things need to be pointed out. If somebody is unhappy enough with the result, the appeal court will tell us the answer and set the new standard. That's how our system works. That is how law evolves. And actually, I would love to have seen how our Court of Appeal would have dealt with the views of the Grand Chamber of the European Court of Human Rights. Police and AN concerns a young woman facing a very serious charge where the argument was whether she should go to the adult system to be sent to prison or stay in the youth court. Amongst other things, this required looking at the disadvantaged situation of all young women in the youth justice system, which I think is an issue everywhere. The decision-making exercise by reference to the Act was finely balanced. The result became crystal clear by reference to the Convention and other rights materials. In other cases, Police and JV, which addresses issues to do with the age of criminal responsibility. And again, the Convention materials were hugely influential, not just in coming to a decision, but by explaining it by reference to the general comment. There are cases drawing attention to the ongoing criminalisation of care and protection, such as LV and more recently SD, which I think speak for themselves. But that is the area that troubles me the most because practice in that area is just not changing. And so I think we need to bring in everything available in our armoury to change that. Recently, Police and HN is a first attempt to understand and include the CRPD in decision-making. The unavoidable conclusion is that we are not capable of respecting and upholding rights under that convention on almost all levels, the way the system is set up. from diagnosis to disposition and most things in between, to the provision of supports and services based on need, we do not have a system that comes close to respecting and upholding the rights under the CRPD adequately. There are some things being done well, most notably the vital role that communication assistants from Talking Trouble are playing now to enable meaningful participation of children in the justice processes. But that shines out as one of few bright lights in an otherwise dark landscape inhabited by the many children with disabilities. Which brings me to the last part, which is what has been happening, what have I learned so far, and yeah, what I want to encourage you to think about and do. What has surprised me most is the reaction to drawing attention to issues and concerns by reference to the rights framework, and where it's been relevant, the treaty as well. Yeah, calling issues out has been taken as a call to action, and instead of appeals, actually of which there haven't been any, several things are now happening to address the issues and concerns that were raised. What we all want is justice and better outcomes for all our children, and to get there, I think we need to call to our aid everything that's available to achieve that. Okay, sure, in New Zealand we've been given this mandate to use the conventions in the way I described. But surely all countries who have ratified these conventions have given the guarantee I spoke of before. Surely the conventions are not only available, they are the guarantees given by our respective countries for better outcomes for all children, including the most vulnerable. Look, we all work in a system that only evolves by the pushing of boundaries. That's how the law develops and improves over time. In this area, there are boundaries that must be pushed. What I hope you will see from the examples I have given is the potential of the conventions to enable that to happen in a principled way. Whatever your role, whether it is policy, advocacy, research, a social worker preparing a report, a lawyer preparing submissions, a judge making decisions, we should be using these tools because that is what they are there for. And that can be scary, I know, because it's not easy to stick your neck out and try something new that others might criticize. And we all have audiences whose opinions we can't ignore. What I want to encourage you to do, if or when those thoughts enter your mind, is remind yourself about who you're doing it for. And if you don't do it, who will? Lastly, I'll just put up the final slide. Yeah. What was the outcome in the castle? Think about it. Go out there armed with more than the vibe. Think about what happened when the right tools were called upon and presented the right way, and start using these conventions to further support the advice, the submissions, the recommendations, or the decisions you are giving or making, and be bold and brave in that. Remember why and for whom you need to be. Nearly finished. I'll just get the last slide removed and say, kia kaha, kia maia, kia manawa nui. Be strong, be brave, be steadfast. Kia ora tātou.
Thank you so much, Judge Fitzgerald. And I'm now going to hand over to my co-moderator, Dr. Plague, who's going to give some points of observation. I'll give a couple of points, and then we will open up to question and answers. Thank you so much for pushing those boundaries, for doing what you are doing. And I'm sure that many people here will also feel that, you know, what you've said is so inspiring and feeds into what we hope to see, that much urgent change for children and young people. I'm going to pass over now to Dr. Plague, who will give some points of observation. Thank you.
Thank you very much, Faith, and thank you, Judge Fitzgerald, for this powerful presentation. As Faith was saying, my name is Tony Fitzgerald. I'm a senior lecturer at UNSW Faculty of Law and Justice, and I would also like to acknowledge the Gadigal people of the Eora Nation, where my home is currently seated, and to pay my respect to elderly, past, present, and emerging, anyone who is joining us today from the different Indigenous lands in Australia, in other places. There are so many issues that Judge Fitzgerald presentation have raised. I would like to briefly mention some of them, and then to ask some follow-up questions, if you don't mind, and encouraging all of you to pop your questions at the chat functions. Some questions have come up. Please, if you have any questions, please populate the chat function. We've heard about different, the journey that Judge Fitzgerald took that led him to start using the Convention on the Rights of the Child and the Convention on the Rights of People with Disabilities in his decisions. And Judge Fitzgerald was honest enough to suggest that it began in 2019. So roughly 30 years after New Zealand have ratified the convention. And as rightly pointed out in other places around the world, the framework exists. The Child Rights Framework is here with us since 1989, formally, after being adopted by the UN General Assembly. It's been kicking around since 1924, if you would like, since the League of Nations adopted a Declaration on the Rights of the Child. So at least in the legal world, we are not stranger to the concept of child rights. And the question is why it's not being utilized in practice and in the court more often. One suggestion is that it needs to be explicitly incorporated into legislation. And surely the amendment to the law in New Zealand have led Judge Fitzgerald to start using it more often. But I think more interestingly is the question of awareness that was mentioned in the presentation, also at the change function. And we know that from our work here with this DTP project that start with the educational training project, because even if the framework exists either in the international level or in domestic legislation, it still doesn't mean that it's being used in practice. And while some might employ the language of the best interest principle, for example, which features in each and every jurisdiction that participants of this webinar join from, it can mean different things, but not every time that you employ the best interest principle, it means that you employ it and execute it and protect it in a child-friendly manner, the child rights-friendly manner, which brings to mind the question of awareness and training, and whether changes of formal legislation is the highway forward to better protect child rights in practice, whether we should also see some much more knowledge at the legal profession for judges and for litigants as to what the convention said and what it can say in particular contexts. We heard a lot of examples about using and protecting child rights in the context of juvenile justice. We have the 2019 General Comment by the UN Committee on the Rights of the Child that shed much needed light on how a child-friendly justice system can look like, and still lots more work needs to be done in that domain as well. And therefore, I would like to kick this conversation with asking a question, or two questions, if I may. First, are we playing a chicken and the egg game here? Is it a matter of raising awareness for judges and litigants, or do we need to see the law changes first, and then through the process of implementing the law, more local knowledge about child rights will be developed and therefore will be exercised in courts? Which leads me to the second question, asking Judge Fitzgerald from his point of view, looking from the bench, what would you expect litigants to do when they represent children? How a robust child rights litigation and child rights advocacy will look from your point of view?
I've understood the question correctly, and the sound quality, I must say, isn't good here, but it's to do with awareness and training here and use of the conventions for litigants and proceedings? The answer to that's pretty simple. It was August last year before I presided in one single case where any lawyer even mentioned either convention. No lawyer has ever mentioned the CRPD ever in any single case. And so for more than a year, I've been trying to see what education can be organised at this end to excite lawyers to be using these tools more. But getting help to see that happens proving difficult. I've sent emails to people who I hoped would support that, which have gone completely unanswered. It was only when Jennifer Braithwaite, who I met recently, got on board that there's been someone here who's indicated great support for helping organise training, because I think we need to build a workforce who are advocating to the standard they should for children by using all the tools we've been given. In fact, I have to say, I see far more use of the CRC by social workers, far more than I see by lawyers. And I would love to see people who are able to support education being provided, willing to help with that. And it might start by just responding to emails when they're sent, asking for that help to be provided.
That's interesting. Why do you believe that social workers are the key, or one of the keys here, rather than focusing on lawyers?
So what was the question?
I was curious about your remark about the social workers and about the usage of child rights language and framework in their work. And that should be our starting point if we speak about education, rather than to educate and raise awareness among lawyers who represent children in court, or represent, for that matter, the welfare agencies.
I suppose actually I probably need to come back and emphasise what I said at the start. Everybody exercising powers under the Act should just be doing this as a matter of routine, because we weren't asked to do this as an optional extra. The language in the Act is strong and mandatory. We must apply the provisions of the Act. We must respect and uphold convention rights. And so why that's not yet happening as a matter of routine, I'm just not sure. Well, I think I do know, because everyone's very busy being busy at work, but I think it would help if there was more education provided for professionals to help give them ideas of how they could be doing that.
If again, how often do children have the possibility to participate in proceedings in front of you, either in direct participation and to be heard by you, or through their legal representation?
Well, almost always. I mean, the way the Act is framed clearly expects that I will almost always see children, because I have a duty to not only explain to them and others what's going on in a manner and language they understand, but I have a duty to encourage their participation. So you can't do that without someone in the room. And I think this is an area where things are going well compared to others, because of the crucial role we have from communication assistants to enable better understanding, and importantly too, training for professionals to know how we can communicate in a way that's accessible to young people. But I think the law here is crystal clear. It should almost never happen that the child is not there for you to see and talk to when they're at an age to do that.
Thank you. Faith, you had a question as well?
Thanks, Noam, and lots of really interesting and important points raised there. It's quite evident when you, and I hope many people have had access through DTP to read the judgments, and I think a few observations that I have. Not only, are academics around the world spending time, on rewriting judgments projects, that's happening in the feminist space and the children's rights space, and Judge Fitzgerald's judgments represent that pushing of the boundaries, something new, and they are exciting for us to see, and you know, hope that others will follow. In your judgments, Judge Fitzgerald, you speak to children and young people, and you present, you know, if you were in their situation, in those circumstances, navigating the systems that you know, many label as being broken, that you or others might respond or act in the way in which the child or young person has in that situation, and you humanise things. How important have those instruments been to the approach that you take when you explain to children and young people about the decisions, but also how you explain to them about how systems, as you say, have let them down? And I'd be really keen to hear about, you know, through the cases and your interactions with children and young people, your approaches. We know internationally, you know, and some very high profile cases that have gone to the European Court have really criticised judicial officers in their communication and court setups, etc. So I'd be really keen to hear about that. The second point would be, because the Convention on Persons you know, Rights of Disabilities, I'd be really interested to hear about you know, the intersection between that and children and young people's experiences. I know that in the space of neuro disabilities, we've seen with the general comment of 2019, you know, the basis of, you know, new scientific evidence, and I know, and I can sense through your judgments that that's something that you're you know, very keen on embedding in the decision-making process. So I'd be really keen to hear about that as well, if you have any comments. And then I'm going to pass over to Noam to open up to the audience. So thanks, Judge.
Well, so on that first issue about communicating with young people, yeah, I think I have become more thoughtful about how to do that as I've become more aware of the presenting issues most have, including the huge levels of anxiety they will have in a room that must be extraordinarily uncomfortable, and to try to make that room safe enough to enable communication to happen in a way that would allow for their understanding and participation. So that's had a bearing on how I would choose when to let them know the answer, which would usually be first instead of waiting till the end, sometimes not even dealing with all the legal detail until sometime later. But I do think the convention material has added a layer of responsibility, I feel, on this issue, because in cases I do feel somebody who's part of a system needs to say in a way that allows them to have some realization and some dignity that why they have behaved this way is seen in a context. Maybe the best way, I think, is for people to read the decisions, but in that one for that girl recently, SD, somebody had to tell her on behalf of a system that had been so cruel and unfair, sorry, because I just think that was necessary to give her some faith in a justice system, some sense of dignity around what had happened, and able to move on. The other question, sorry, Faith, you might have to remind me what part 2 was.
Well, I'm just aware of the time, so it might be best. I'm fortunate enough to get lots of great chats with you, Judge, and learn from you. So perhaps we can let Noam now open up to questions. I see there's lots of hands up. We've had an absolutely wonderful list of participants here. So very excited to hear from others on their questions. So thank you for answering that. And over to you now to chair. Thanks.
Thank you very much. Justice Nelson, you have your hands up. If you could introduce yourself and ask your question.
Thank you, Norm, and I'm very happy to be part of this this forum. I'm actually in Geneva. The committee is in session right now. We're halfway through our session, so this is just perfect timing for me. I'm conscious of the time, so I have a comment and a couple of very quick questions. My comment is Tony Fitzgerald is one of the greatest advocates in New Zealand for children's rights. Malo Tony. I wish every youth court judge in every youth court in the world would do what you do and constantly refer to the CRC in their judgments. That leads me to my first question. In terms of the training of lawyers in universities in New Zealand, is there any specific attention paid to the CRC, provisions of the CRC and specialist training in child rights in the actual academic institutions in New Zealand? And second question is, the age of criminal responsibility, which I see is being raised in the chat, is always a matter of concern for the committee, and New Zealand's age is still very low. And I wonder what moves are being made, if any, to address this issue in Aotearoa. Thank you and good luck, and thank you to everybody. Thank you, Norm, and the organizers of this forum.
Well, kia ora, Clarence. As to that first question, I feel flattered that you would think I was young enough to know what's being taught in university. It was certainly not taught in my day, and I don't actually know what's taught in terms of rights at university. I'd love to know.
Not much.
On that second issue, that issue regarding age of criminal responsibility needed to be addressed in a recent decision in June. I touched on it. I think it's called JV. But that was one of the ones where the reaction's been really good. Everybody's rallied around and said, hey, look, let's do something about this. And now there's a whole lot that's happened, including a seminar in November for the entire youth justice workforce. And so, again, I think in some ways it's been helpful to have the general comment that you provided, thanks so much, but to have all these issues put out there, because I think it's making people more thoughtful about the issues that we need to be considering. And I think the rights framework broadens people's awareness of just what the issues are, what the options are, and gives us more tools to work with, I think, to help inform good decision making.
Thank you. And those of you who didn't recognize, we had a question coming from Geneva from Judge Nelson, who is a justice of the Supreme Court of Samoa, but also a member of the UN Committee on the Rights of the Child. I think, speaking from what I know from my university, our universities in Sydney and around Australia, child rights is not being taught widely, but it is being taught, but only as a niche course. So it's an elective that we run, but we don't see it being taught in child approach, and others are more than happy. If someone can correct me, you don't have much child rights training in criminal law courses and similar core courses alike. So you're either interested in the subject or not, and then the question whether it's available for you to take it as an elective in your respected law school. Question about a few comments were made at the chat about the minimum age of criminal responsibility. It's extremely low in Australia. It's still 10, with the ACT raising it now to 14. 14 being the international good standard as per the UN Committee on the Rights of the Child, as it was stated in general comment about juvenile justice. It's still very low in other places around the world. And I was wondering, Justice Fitzgerald, going back to your point about the system focusing on rehabilitation of young offenders, how the age of the offenders that come before you and affect the ways in which you approach their sentencing.
Is that me? I'll try. I need to just keep this succinct, but the the age of criminal responsibility in New Zealand is 10, but 10 and 11-year-olds can only be charged with murder or manslaughter. However, since 2010, some 12 and 13-year-olds can be brought into the youth court facing criminal charges if they're serious enough or they're repeat offenders. But that comes with an ability to have the prosecutor think about taking them to the family court instead to deal with as a care and protection issue. So I suppose for me, the answer is the importance of recognising the desirability, at least, of responding to the behaviour of children at that age that brings them to police attention as a care and protection issue, not as a criminal justice issue. And we've got the ability to do that. So it's 14-year-olds and older who are the ones able to be charged criminally and brought to the youth court. And of course, their age is a significant factor in deciding outcome. It's probably important to say that about 50% of all children and young people who come to the youth court in New Zealand who admit charges or their charges are proven will have those charges discharged at the end with an order that leaves no record that ever come to court facing the charges in the first place. So, I mean, that is a good feature of the law. It allows for that issue about sentencing to be deferred to give them a chance to complete a plan and walk away without a lasting record.
Thank you. We have Bruce Adamson with us, who is the Children and Young People Commissioner from Scotland, who was a guest in our webinars in the past. We've also woke up at 6 a.m. To join us. And I think he would like to make a comment about the usage and utility of the CRC in litigation. Bruce, please.
Thanks so much, Norma, and thank you, Judge Fitzgerald. That was an absolutely inspiring presentation. And I know that there's lots of people on this side of the world that are up really early to hear it, and I'm glad that we did. On that point of strategic litigation, you've talked a lot about the convention and the general comments being useful tools. I wonder about what other tools might be necessary for the judiciary and the legal community to interpret, but also really the role of strategic litigation and cases in being part of that education and that drive to use the conventions to actually change the way in which we make decisions. And you talked about the fact that there aren't many lawyers making these cases. And so what do we need to do to ensure that cases come forward and strategic litigation is used to deepen our understanding of the law, do you think?
Yeah, I've got a strong view about this. And I believe that the law we've got in the Act with the conventions and the treaty enables the type of transformative change I mentioned at the start of my speech. What I am troubled by, which I don't think is well enough understood, is practice. And practice often doesn't accord with law, and practice can be contrary to law, but it's what people do. And unless people in positions of power who can change practice have the wherewithal and the insight to convert practice to accord with the new law, things won't change. It's why 30 years on from the Act coming into force, the key features of it, particularly for young Maori, were not being observed at all. And what's troubling me is I can now see why that happened, and I can see that if we don't convert practice to accord with law, in 10 more years, nothing will have changed. And I just don't think that a lot of the people who comment publicly, the one that, we get lots of research, expert reports, but they've been saying the same things for 30 years. It's practice where change is needed. The workforce out there who are hungry, needing guidance from someone to say, hey, this is how we're going to do it now, because whatever. And I don't feel there's enough of that happening, because I don't think there's enough understanding of the difference between just passing a new law that sounds great and giving people tools without teaching them how to use them. And that's where the action's needed. That's where the energy and the inspiration's needed to get people excited about picking up what we've been giving and use it. It's just not happening. And where I sit more than 2 years after the law changes, I just can't believe that if you, I mean, even those decisions that are only a month old, that those are the sorts of things I'm having to decide about and say in courtrooms. So my own view is we don't need more expert reports. We don't need more law change. We just need what we've been given to be used properly by everybody exercising powers. The other thing I just want to add there is the commentary almost always here when things go wrong is a beat up on our welfare organisation, Oranga Tamariki, portraying the view that that's where the problems lie and the solutions will be found by just dealing there. But that's simply not the case. Nobody exercising powers under the Act is yet doing that to the extent needed. And again, that's because there's not enough understanding about the need to affect practice and those with the ability to do it to drive that.
Thank you very much for this. And I think this is a perfect moment to bring this webinar into an end. We are, I think, with the message that we need to do much more in terms of educating the profession and educating all of those who work with children as to the merit and utility of child rights approach and the change it can bring to the way that we function. Thank you very much, Judge Fitzgerald, for this wonderful and inspiring presentation. And thank you all of us for joining us. This is a collaboration between the Diplomacy Training Program, Youth Law Australia, and Australian Lawyers for Human Rights. Dr. Felik senior lecturer at the ANU, and myself are the academic moderators of this program. That's what we are trying to do. We're trying to bring knowledge and build knowledge in the region and other places about child rights. This was our 9th webinar. Please join us next month. We are going to speak a bit more about child rights in practice, more in the welfare space, with some experience from lawyers and organizations from Victoria. The recording of this webinar will be available at the YouTube channel of the Diplomacy Training Program, and all of you who joined us today will get an email later today with the link and all the other information that was populated, that has populated the chat today, and some information about our next webinars where you can enroll. Thank you very much again, for Judge Fitzgerald, for your presentation. All of you for joining us, and have a good evening.
Yeah, no,